Within the Murdaugh case, there are so many villains who are easy to identify, but not all of these evildoers are obvious. As these cases continue to twist and move forward, we will continue to drag these vampires into the sunlight and show the world who the true villains really are.
First-degree burglary, kidnapping, possession of a weapon during possession of a violent crime, and felon in possession of a weapon was 2014 GS 210813. And Mr. Ralph Wilson represented Mr. Brooks, and Assistant Solicitors John Jeffersinger, Esquire, and David Richardson, Esquire, prosecuted the case. It proceeded to trial before the Honorable Michael G. Nettles, and the jury found Mr. Brooks guilty as indicted. Judge Nettles sentenced Mr. Brooks to imprisonment for concurrent terms of 30 years each for armed robbery, first-degree burglary, and kidnapping, and 5 years each for the weapons charges. Mr. Brooks did file a timely notice of appeal, and the Court of Appeals affirmed his convictions on June 1st, 2017, in opinion number 2017-321. It was filed August 2nd, 2017, and permitted to return on August 18th, 2017. Applicant timely filed this return, or filed his application for PCR, and the state filed its return. Currently, Your Honor, this case is in a discovery phase, and we are currently working with the Florence County Police Department to receive discovery on the case. We just wanted to put that on the record that we are working to get discovery in this case.
Thank you, Your Honor. Briefly, Judge, I believe I am Mr. Brooks' third PCR attorney. Part of the issue that we had in this case, in my investigation for this matter, is that Mr. Wilson, who represented Mr. Brooks, by the time I was involved in this case, no longer had a copy of his file. So we've been working with the Attorney General's office to get everything we need to basically recreate the investigation, particularly since the case involved a number of issues of DNA testing, clinical testing, and stuff. So we want to just put a status on it. We appreciate that.
Any comment, Mr. Brooks?
No, sir.
All right, very well.
Thank you, Your Honor.
Thank you all. We will recess these matters and be ready to go forward.
Would you mind placing this next to the tissue box? With, right there. Yeah, over there. This way up? That's okay. Do you need
Oh, okay. I'm not used to that. We're gonna be standing, or we're gonna be sitting?
Write it down, Hayden.
Any of y'all report?
Yeah.
Russ, you'll see.
I guess.
Do you need an XLR?
No.
Yeah.
Okay. No, it's all right.
There is no windows, but it is much colder. That's like Richland. Back in the day, remember?
We had arm shot set up.
Yeah.
But
Great.
they don't have a splitter to get ours hooked up.
No,
They're on camp.
County courthouse on Summer Street, third floor.
Oh.
Big, you're talking about Greenville.
No.
Oh, Richmond. Yeah, no, I'm talking about Richmond. When we have courthouse on Summer Street.
Yes, we are.
Big windows, nobody sees. Try to get in there and you didn't have court in July, August, so we could wait you know. So, you know, that bounty of what these previous.
Yeah, unfortunately, they don't have a whole box, so it's camera audio.
Can I help you?
He gave me permission to walk up there. I just
I
don't
have
want
nothing to do with that.
charge through you guys.
Mm-hmm. Yeah. Tracy's doing all right. Yeah. All right. Yeah. Want this one? Bye-bye. Yeah.
What goes on?
Hey, Tracy.
Well, we'll get some sign back. She can present the court, move it down.
Oh, no, I don't have my card.
But, I mean, if the finish works doing it.
They don't have the option.
Done. Done.
We have to turn it on. Right, I think you have to turn it on.
Let me get my SD card in there. Sorry. Are you on live stream?
Oh, yeah. What? Yeah, just what? Without you putting it on? He prefers me to dress. I know he does.
See what happens if I do this.
Monk takes a picture of me, I take a picture of Monk.
Why not?
Turn about.
Okay, how
way.
Give me one.
Turnabout. You don't have a photographer on the paper here. Why are you taking pictures?
That's what Mojo is.
What?
Mojo, local journalism.
Yeah.
We are.
Yes, thank you. Oh, well, we need a client. We just need our client, we're ready to go. Thank you.
Just talking. Just go to the podium. That right there. Just go there and talk. Just talk. Yeah, just count. Okay. How do you? Just count.
But the right.
1, 2.
All right. No, that's all right. Come back. They're interfering with one another. So here's what I'll do. I'll turn this off. Oh. I've never been able to figure that out.
Is it on?
Who's it?
Ours.
Can you hear what we're saying right now? No?
Well, in conversation.
In our conversation. Somebody, whoever move that away from us, so we can call our client. I'm angry, who's that one too? Can y'all not put that between us?
All rise, court come to order. You may be seated.
Morning, Your Honor.
Morning, Your Honor.
Motion, yes.
Your Honor, we're here obviously on the state of South Carolina versus Richard Alexander Murdaugh. It's 2021 GS 15, 592, 593, 594, and 595. The defendant, of course, is present with his counsel, Dick Arpulli and Jim Griffin, and we're here on the defendant's motions to compel as well as a motion to strike notice of alibi.
Please, court, Your Honor.
Yes.
I'm going to try to handle this in a somewhat expedited fashion if we can, not to belabor anything. And the sequence of the filing of these motions began with a motion for a forthwith order. And I think before we move on to the other motions, it's appropriate to discuss the context of why we need a forthwith order. For example, and the state has alleged they've given us a terabyte of data. Now they've said it's not a terabyte, it's somewhat less. But that's not really the issue. We're not judging discovery by the pound, if you will. We're judging it on two standards. One, have they complied with Rule 5, and have we complied with Rule 5? And two, have they complied with Brady versus Maryland? The second piece of that is much more nuanced because we get what somebody, apparently the state gets to interpret as exculpatory material. But by way of example, how difficult this has become for us with 90 days to go till trial. We served discovery under Rule 5, the discovery motion under Rule 5 on the state. They served some 4 weeks ago, almost 5 weeks ago, a reciprocal discovery motion. One of those things is, what's your alibi? Now, I've been doing this 4 decades, probably 3 decades under Rule 5. And when a prosecutor, solicitor, and I did the job for 12 years, serves that reciprocal discovery, they say, alibi for such and such a date at such and such a time. The states, we've asked them for that. They continue to not give that to us. And in their response they filed last night, they said, well, you know, if you look at the discovery, if the defense attorneys look at the discovery, they'll know it's between X and Y. Well, 2 things. One, we're supposed to look for that single straw in the terabyte of data that tells us what time they say these homicides were committed. The coroner in his death certificate says 9 o'clock. Are they relying on that? Is it broader than that? Is it plus or minus 5 or 10 minutes? We don't know. So at the minimum, they're playing a game here where they're refusing to do what and I can read the rule to Your Honor, but you know what it says. It says, must give us a time and a date. They've not done that, and still in their motion yesterday, they refused to do that. That's one issue. You're going to see they're going to raise issues about a polygraph, and Mr. Griffin's going to address that later on in that motion concerning Mr. Smith in more detail. But clearly, Mr. Smith has admitted to the state that he visited the scene of the murder on previous occasions to commit illegal acts, that is delivering drugs, surreptitiously. So we've got him at the scene of the crime previously. We've got him committing illegal acts there by his own admission. And then we think, they say, they characterize it as failing the polygraph. We would like our polygrapher to look at the charts, to look at the data and see if there are nuances there that are helpful. And more importantly, even the state in their motion can see that it's not always inadmissible. There are circumstances under which a polygraph or lie detector can be admissible. So we need that because there's a potential for exculpatory material there. In addition to that, we've had, Mr. Griffin's had conversations where they promised to produce things and they don't produce them, or they produce them weeks after we ask for them. Now, if this was a car wreck case, just a simple car wreck case that Your Honor's trying, and somebody moved to get the damages in a filed discovery motion, and they didn't produce it within 30 days, there'd be a motion to compel Your Honor to decide whether they get it or not. We don't have that mechanism in a trial where somebody's license day. That literally, if he's convicted of this, he will never see the light of day again. So we're not being accorded access to information. We've hired experts. They can't render an expert opinion to us till they see what the state's experts relied on. Also, I'll give you a simple example. They have produced to us the autopsy report done by a doctor at MUSC. What they've not produced are her notes, her diagrams, any data, anything she did in preparation for that report. The forthwith order would allow us to subpoena those from her. And Your Honor, if I could have those notes, where's it? Right here. Okay. Your Honor, I would propose, and of course the state opposes our ability to subpoena material until we get ready until trial date. And if we discover material subpoenaed that requires us to get more experts, requires us to do additional investigation, we're gonna have to move for continuance. Why should we? And by the way, there's a federal rule that allows this. This has been done by custom by a number of circuit judges in the past. I'm gonna hand up to the court something we would propose to include in a subpoena issue. And Your Honor, for the record, what this would say is, pursuant to court order entered on such and such, you're hereby required to respond to the subpoena served upon you and produce documents and materials requested forthwith. If you have a legal basis for objecting to the production of the items requested, you must serve your objection upon the attorney issuing the subpoena immediately. The attorney may then file a motion with the court seeking an order compelling your response, and he may be required to appear before the court. So, I mean, this is about as unobtrusive as we get. They object, we have to move. They don't have to move to quash. And then there's a hearing where they can appear, and if Mr. Waters wants to enter appearance on that, although we don't believe he has a dog in that fight, if we're subpoenaed from some outside agency or person, some civilian. Now, if we subpoena something from a state law enforcement division or whatever, certainly we would expect him to appear. But there are, I mean, and you'll hear in a moment, a number of things we've asked for we haven't gotten. This idea that somehow that, you know, they're doing the best they can. They indicted him months ago, and now they're telling us they're still, for instance, DNA, you're gonna hear in a minute, they're still looking at DNA. They're still doing an evaluation of DNA, and we're all, if you take Christmas and Thanksgiving out, less than 90 days away from trial. I mean, at what point did they stop investigating this case? They should have stopped before they indicted him. They should have stopped. They should have had everything they needed when they indicted him. By way of example, we're going to hear about Eddie Smith and his polygraph even more. There's unidentified DNA under Mrs. Murdaugh's, Maggie Murdaugh's fingernails. They never, what they told us verbally, we've never gotten a written response. They've never taken a DNA sample from Smith. We would move, if they don't do it, to get that DNA so we can compare it. I mean, we're again, less than 90 days away from trial. They just dumped, and we got 2 dumps in the last 48 hours. Some answer some of the questions, sort of, but we shouldn't have to be ferreting out the truth through these massive data dumps we get. And why couldn't they push it? I mean, they explained to us way back when, push a button, it spits out. Well, that hasn't proved to be true. And in addition to that, their investigation continues. And it continues because as we get information, it ain't adding up. Now, you know, they have promised us, Mr. Griffin's going to go into this in more detail, cell phone data or data from cell phones location that would be, I think they put in a motion earlier, compelling proof of his guilt. That motion you heard a month ago. Where is it? We have experts that we've hired that are waiting to get that data to vet it. And I can tell you without fear of contradiction that much of the data that they've given us that they say says X doesn't say that. It may not say anything. Or in some instances, it says something different. We need to get ready for trial. We don't want to be sitting there on the eve of trial, 2 days before trial, and get another terabyte of data dumped on us for us to look at. This is not trial by ambush. This is due process. And Your Honor, I'd ask you to give us this forthwith order so that we might go out and subpoena evidence we think we need for our experts and others to evaluate the strength of the state's case. Thank you, Court indulgence. There are a number of items we're going to address in the other motions. I mentioned some of the items that we're going to address in the other motions, only so that you get a context of this forthwith order. And for the life of me, I can't understand, in the sense of fairness, why the state would be opposed to us going out and independently investigating this case. Thank you.
Mr. Waters. Thank you, Your Honor. Just to start, of course, with the forthwith order, and the state has no objection whatsoever, of course, to the defense investigating this case. That's not the nature of the objection. The only objection is what is allowed by the rule. I have certainly no issue whatsoever with the defense being able to, as is the typical process, to approach Your Honor in the event that they wish to seek an order compelling some materials be produced prior to trial. That's not the problem. The way their order was written would essentially give them more power than the state grand jury. It would essentially be unfettered subpoena power without any sort of check or balance on that, or even an obligation to disclose that to the other side. All of our subpoenas, they get to see in the state grand jury case. And so we think the normal procedure is the way to go, and that is if they have something that they need to subpoena ahead of time, I will have not the slightest objection. They can submit an order. We can take a look at it. Any party of the subpoena has an opportunity to object if they want to, and it could go like that. So that's not really the issue. With the issue of the alibi, again, the case law, which we cited in our response to Your Honor, makes very clear that it's not as formulaic and specific as defense counsel would command. They've gotten extensive discovery. He said, oh, it was a terabyte, now it's less. No, it was always 3/4 of a terabyte. But that information is available to the defense. The indictments themselves specify that Alec Murdaugh killed his wife and son on June 7th, 2021 in Colleton County. It's extremely well-known, maybe one of the most well-known facts in the state that occurred at the property in Moselle. I've had conversations with Mr. Griffin in which I note that there is a video that shows Alec present at the scene, despite his denials, with Maggie and Paul at 8:44 p.m., not long before their phones ceased any meaningful activity. And it's about 9:06 p.m. when his car fires up and he drives over to Alameda. So we've made that clear to the defense, and they, of course, know the 911 call occurred at 10:06 p.m. They know this. This is a manufactured issue to try to act like that they don't have this information when in fact they do. Your Honor, this is, of course, this investigation is unlike anything anyone has ever seen, because not only does it have at its core the most important case, and that is the murder case against Alec Murdaugh for murdering his wife and son, but also it has an amazingly complicated white-collar case where his use of his law license was allegedly exposed in a manner that people have never seen. It has a narcotics aspect to it. It has a number of aspects to it, and the discovery in this case is massive, and it is being provided with all due diligence. They have constantly reached out to me, and we're talking about things that are not Rule 5, but things are beyond Rule 5, and we're providing all of those. I have this checklist right here. Mr. Griffin and I talked on Thursday. They didn't say a thing about a motion to compel. Here's my list of that stuff with my notes on it, and I didn't say no to a dadgum thing on this. I said, absolutely, we'll get you that, we'll get you that, we'll get you that. And that's been our way of working this case from the beginning. This motion was more about trying to prejudice the public about this polygraph with Curtis Eddie Smith, which, as I explained in my response, they totally mistake what that means and what a polygraph is. It's very telling, Your Honor, that they wish to make this case about Eddie Smith. Their defense is focusing on trying to make a big deal out of a polygraph, which, as Your Honor knows, is generally inadmitted in South Carolina courts. I'm not aware of it ever happening. And of course, they're also acting like this polygraph means something that it doesn't. That's not how polygraphs work. It's not like it is in the movies where somebody asks a question and the person answers and a little red buzzer goes on. That's not how they work. And because of the questionable reliability of polygraphs and the subjective aspect of them, they have never been admitted in South Carolina courts. They are an investigative tool. So what this motion really was about, in 2 or 3 pages of that, was to really detail that polygraph for its effects on the outside world and not for any legal reason. The second thing that they did, and this is very telling as well, that they're so desperate to make this case about Curtis Eddie Smith, is they recount some scuttlebutt story that Eddie heard that they know has no basis.
Your Honor, I hate to interrupt, I would object. I was arguing the forthwith motion in a few moments. We'll be arguing the motion to compel, which will go into the details of that. And again, I apologize. I did mention some aspects of it, but really, if he's going to agree to a forthwith order, we can talk about the mechanisms of that. And the other issues about Eddie Smith and whether he made stuff up or didn't make stuff up, Mr. Griffin and Mr. Waters can discuss in a moment when we discuss that specific motion to compel.
I'm not going to limit Mr. Waters, and there'll be an opportunity to respond by Mr. Griffin and argue fully as well.
All right, thank you.
I'm not going to tailor the state's argument. You may
Thank you, Your Honor.
proceed.
Thank you, Your Honor, I appreciate that. Again, going back to the polygraph, we are the ones who provided that polygraph result to the defense back on August 31st, 2022, as soon as we were authorized to by the protective order. We are the ones who provided that video to the defense. And again, all of the discussion in their motion, putting pictures in there, putting a close-up of a spike, which doesn't mean what they say it means, has no basis and has really no bearing on the legal issue that is before the court. They asked for the polygraph charts. Sure, we'll get them for you. We got them yesterday or the day before. They'll be uploaded before the end of the week. As soon as they asked for it, they were provided to them. They've asked now for 3 additional charts. Sure, we'll provide that. They've asked for the autopsy notes. We have asked MUSC. We'll provide those as soon as we get those. So there's not been a thing that I've said no to. The only thing I've said no to is a complete dump of every email between SLED about this case. However, we are going to conduct a Brady review and provide that information. And I expressed that to Mr. Griffin. But we went through this list on Thursday, 27 things, and I didn't say no to a single thing. That was probably the only limitation that I said on that. And then, of course, this motion gets filed the very next day. Mr. Harpootlian talks about the DNA testing. We provided all DNA testing to this point. He says that there's not a buccal swab of Eddie. There is a buccal swab of Eddie. He points out that there is some DNA analysis pending, which I put in my motion, and that is true. That is true. But you have to understand that this is an extremely complex case, and we're dealing in the age of StarMix, okay, where it's a very powerful technology that allows us to do things that we couldn't used to do when you have multiple contributors to a sample. But StarMix can lead to the report being written in a way that's not what it really means. He points out that there is unidentified DNA under Maggie's fingernails. There are 2 alleles that are there. Okay, there are 2 alleles that are there. And when the forensic scientists at SLED do their analysis, they make judgments about what test would have a reasonable chance of bringing some sort of valuable evidence to the case. And it's a complex determination. They have, from my understanding, plenty of ability and resources to obtain experts, and they can do that. We will get them all the data, and if they want to, at any trial, have their expert come in and make arguments about what tests were done and what not were done, they are free to do that. But we are doing everything in our power within the judgments of our forensic scientists and their good judgment as to what are reasonable things to do that will likely lead to evidence that will be helpful in the case, and that's what we're doing. And in the event that additional samples are run or additional tests are done, they are being done in an expedited fashion, and that information will be provided to the defense in as timely a manner as we can. Your Honor, they talk about the cell phones. They have all the cell phone data. They have it all, okay? And to some extent, they're complaining that they have all the underlying data, but they don't want to analyze it themselves. Mr. Harpootlian says, well, we don't think it says what the state thinks it says. Well, that's what a trial's for. We'll have our evidence up there. We'll have our expert get up there, and we'll say that this is what the cell phone data says, and they have every opportunity to have their expert get up there and say to the opposite. They've had that cell phone data for months. They complained in their motion that they didn't have the Eddie Smith cell phone data, and I identified the actual file in the discovery that we provided them where they received that. They've had an external hard drive that they brought over to our office, and we downloaded all the phone data on there as well. We do have 2 things remaining that I mentioned to Mr. Griffin that I will provide as soon as they are ready. The FBI is conducting a review of the cell phone tower location data, but that's still in draft form. I have been repeatedly calling about that. Special Agent Owen has been calling about that, and that should be ready soon. And as soon as that is ready, I'm happy to share it with the defense. And the other thing is a timeline that's being worked on by an agent that is still in draft form that they are finishing up. And once that is ready, I'm happy to share that with the defense. And so those are just things that are being raised. And if you look through their motion in its entirety, Your Honor, and you look at my responses, every single one of them, it is either we've already provided it, they have it, let me point out to you where it is, or it will be provided as soon as we obtain it. And so there is no issue here that would require any sort of motion to compel. So that kind of leads back to, when I agree with Mr. Harper-Lillian, that does set the context for the forthwith order. And again, I have no problem with them being able to investigate their case. If they ask me for something and I either say I don't have it or I'm not going to give it to you, then the appropriate thing to do then is to seek an order from Your Honor to get that on a case-by-case basis. And that's the way it should work. And we're completely agreeable to that. I think that's the normal process, and I don't think that there's a problem with that. The bottom line is that we're not trying to hide anything. And Mr. Griffin knows that every time he's called or Mr. Harpootlian has sent a letter, I have been responsive quickly. I've addressed their concerns. And even though it might have taken a few days more than they would have liked to get it, I have not said no to them at all. And this is for information that's even beyond what is required by Rule 5. So we are doing everything in our power to give them the opportunity of that data. We're not scared of anything in this case. And we're ready and looking forward to being able to present this case before a jury on January 23rd. Thank you, Your Honor.
Please, the court, Your Honor. I find it amazing that the state does this sort of distraction move with the court. Let me quote to the court Rule 5E1. 5E1 of the Rules of Criminal Procedure. After we serve a discovery motion, which we did under Rule 5, upon written request of the prosecution stating the time, date, and place at which the alleged offense occurred, okay, that's got to be in a written request. The defendant shall serve within 10 days or such time as the court may direct upon the prosecution a written notice of his intention to offer an alibi defense. And then we have to give our alibi defense for that time, date, and place. They've never served upon, they want us to respond to an alibi request which says, we put in our motion, tell us your alibi. Now, what he says is everybody knows there's a video at 8:44 or 8:45, which, by the way, when you look at the video, very convivial discussions between Maggie and Alec. Paul's having a good time. There's nothing to indicate within the next, and according to him, he just said 9:06 or whenever his car cranks up. In the next 20 minutes, he butchers his son and wife, executes both of them in a brutal way. He's then on the phone talking to another lawyer from his car in a very convivial way. I mean, if that's your position, put it in writing so that we then can give you, if it's that time, don't say later on, well, you know, we have new evidence, we're still investigating, and it's not really between that, it's between here and here. We have a right to know if they want our alibi. Now, if they don't want to give it to us, we don't have to give them an alibi.
Was there a written request made pursuant to Rule 5E?
Yes, sir.
And do you have a copy?
I thought we attached it to the motion. Let me make sure.
Your Honor, I believe I have one here, and just to make things easier, it did just quote the rule itself. And again, our position is, based on the Benton case, that that's sufficient given the amount of discovery required.
Your Honor, we only have one copy, but let me hand it up to the court. So, Your Honor, that, and Mr. Griffin will address a bit more of that. Let me go back to the forthwith order for just a second. There is no rule in state court. It's done by custom. There's no requirement that he can cite in case law that we serve him. And by the way, I don't believe I've ever been given a copy of a subpoena from a statewide grand jury before it was served, number one. Number two, after this case was indicted, they're serving search warrants, Your Honor, assigning them. They're ex parte. They're served. Some of them we have not gotten, not some of them, all of them we have not gotten returns on. So we don't know what they got. All I'd ask the court to do is not strap us down the way the state is not. If we see something we want, we serve a subpoena. If the folks don't want to give it up, they tell us, and then we come before you for a motion. I don't know why we have to telegraph to the state our defense. There's no requirement we do that. Now, I'm sure he wants to see it. I'd like to see those search warrants before they're issued, or I'd at least like to see a return after they're served. We're not getting any of that. The other thing is this: the first time we've heard there's a buccal swab on Eddie is today. Has it been taken recently?
No, sir.
It's not in the discovery we received.
It is, Mr. Harwood.
And has it been compared to anything?
Your Honor, the discovery, the buccal swab from Eddie was taken in the context of the side of the road case, and it was compared to a number of items there. As I explained earlier, in the murder case, given the judgment of the forensic scientists as to, based on the SCARMEX results, what would likely be valuable tests to pursue, it was not compared to those. However, that is being done at this moment.
Okay, so it's not, okay, we received, I will say this, and let me make sure I'm correct. We got the Brookside shooting case this week. 2 days ago, and I'm sorry if we haven't had a chance to look at this massive discovery, we've been asking for it since he was charged, when our client was charged in the roadside case. We served that in that discovery request in January. We got it 2 days ago. And there may be a buccal swab in there, but we just got it the night before last.
What did you serve in January?
Yes, sir.
What did you serve in January?
A Rule 5.
You served a Rule 5.
Rule 5 in Brady in January on the roadside case. We got it 2 days ago. In Hampton County case.
Okay.
So, I mean, this idea that somehow they're being open, somehow they're going to give us whatever we want, they're not. And so this forthwith order would allow us to not say, oh, please, Mr. Waters, would you give this to us? Please go look. And then months go by and we don't get anything. Your Honor, this is about due process. This is about equal protection. This is about fairness. We would like the ability to serve subpoenas without going to him first. We don't have any problem coming to you, just like they do on a search warrant, and indicating, as long as we don't have to file it, so we telegraph to him. I mean, we do an ex parte with you, just like he does a search warrant, which is sealed, by the way. We can't see it, and we don't have returns from those. I mean, what's good for the goose is good for the gander. We don't object to coming to you when we want to issue a subpoena, ex parte, and doing something under seal. Now, you may not be wanting to be burdened with all that. And again, we are going to tell these folks, if you don't want to give it up, just tell them, and they'll serve a motion to compel if they feel it's worth the effort. So as to the forthwith order, Your Honor, it's just, if we don't do that and we have to subpoena all this stuff at trial, then we're going to have to ask for a continuance as we digest what's going to be a huge amount of forensic evidence, we believe, and physical evidence that experts are going to have to examine. Now, why should we have to do that on January 23rd? Why can't we do it right now? And again, the safety measure is if they don't want to give it up, they've got an objection. They tell us, and then we have to come before you, which will be a public hearing. Mr. Waters can come. I don't know if he can participate, but certainly their lawyer can participate. That's all I have on forthwith. And at this point, Mr. Griffin's going to argue the specifics of the other motions, although I have infringed on some of his territory.
Mr. Griffin, yes, sir.
Hey, good morning, Your Honor. I do want to put these motions in context. Frankly, I had had a telephone call with Mr. Waters about our laundry list of items that we were missing. It was, as he says in his response, very cooperative, have no issues. But he did tell me in that conversation that he had an encounter with the court where there's a request for us to schedule a hearing, get together and schedule a hearing. In an effort to be more efficient, instead of having to come back with disputes down the road and have yet another hearing, we put our discovery gaps and other information that we were seeking in writing, filed with the court, and so we're getting promises to receive things, but what we're hoping to come out of this is a date by which the court says, okay, Mr. Waters, you're going to provide this. you need to provide it by X day. Well, why can't you provide it by X day? And so that really is in the context of what the relief that we are seeking, even where we don't have any disagreements, where we've just gotten promises. And so that is the reason that we filed the motions, when we filed the motions, because we knew we were going to be before Your Honor arguing about the forthwith orders. And so there's no reason to then file another motion, tomorrow or next week and have to transport Mr. Murdaugh back here and all the media back here. But in any event, I will say we've had very cooperative conversations, and I have no complaints about that. Although there are gaps and there's missing information, and I'll just take the various motions to compel. The first one is the one related to Mr. Smith, and it sounds like the items that we requested, we're told we're getting those now, the charts and the polygraph. They said in their response that they have interviews from the witnesses that we had asked for. We hadn't seen interviews. We did get a discovery from the Hampton County case, the roadside shooting case, that came in on the 18th. In my conversation with Mr. Waters, I said, we don't have these interviews of Mr. Smith that have been referenced in some of the other things. And he says, well, you need to serve a discovery in the Hampton County case. I said, we did that. And so I emailed that to him. No complaints. He didn't think he had it. They've had it since January. It happens. I'm not attributing any bad faith on behalf of the state, but the fact of the matter is, we got the information that he says we have received just 2 days ago in response to our request and then the motion. But what we don't have, and what I'm hearing for the first time is this, that there was a buccal swab. Now we hear today it was not compared against the DNA at the murder crime scene. Because when we get the DNA reports from SLED, they list the comparison DNA of all the individuals they took DNA from, and they took a DNA from a broad range of people. But Curtis A. Smith was never identified on those DNA reports that we have. And so, in Your Honor, when you talk about Brady material, this could be the most significant piece of Brady material in their possession. Sounds like they're working on it now. And so, we'll get it, but when will we get it is a significant question in that regard, Your Honor. And then, and they said they'll get us charts, and we appreciate that. We did get the interviews, videotaped interviews, and there's information in there. Yeah, on the 18th.
Just a moment. So there appears to be someone in the corner. I don't know if she's asleep or what, but she could easily leave. Having to step out. So to wake up.
I should do better, Your Honor.
Your Honor, you want me to jump in now?
Thank you, Your Honor. And so that's really encompasses the information that we had requested on Mr. Smith. Going through the follow-up motion to compel that we filed, and this really does cover a lot of items that we've spoken about on the telephone that I had with Mr. Waters, but and I just want to take them in line. Number one in our motion is any and all test results of Paul and Maggie's clothing, including DNA and GSR. We've not received that, and frankly, we don't believe that their clothing that they were wearing the night they were murdered has ever been processed for DNA or GSR. And we just need to know one way or the other if it has been processed for DNA or GSR, and has the DNA been cross-checked. I think, Your Honor, will understand once this case unfolds that there were very close encounters, it appears, with the murderer at the time of the murders. And it's certainly not beyond the realm of belief that the murderer would come in contact with Paul and or Maggie's clothing. Now they have taken DNA off clothing, but I can't see anywhere where they took DNA off Paul or Maggie's clothing. And you know, if they're not doing that, you know, we'd like to know why, because if they're going to compare Curtis Eddie Smith's DNA to something, I mean, that would be or anybody else's. They should do it on the clothing. And frankly, we haven't seen where they cross-check DNA on CODIS, where they put it in the CODIS or not. And that's a national database for DNA. The second item on the list, Your Honor, is GS.
Let's go item by item so we can get to the end of this. Item number 1.
Yes,
You
yes.
want to respond to that?
So item number 1, testing results on Paul and Maggie's clothing. As I said earlier, they do have the results of many tests that have been done that the forensic scientists determined had the possibility of forensic merit. And again, they can raise whatever issues they want to raise. Our scientists can explain, and our agents can explain as to the decisions as to testing that were made. But there is nothing that is being withheld at this time. As I said before, if in the event that any testing is done, I will advise them immediately, as I have, and that will be provided in an expedited manner.
And were these test results provided prior to this motion being filed or after?
Yes, sir.
Pardon?
I believe the GSR has been, that was provided once the murder discovery started, is my recollection, Your Honor. And I can check on that. I'm a little bit, we can check on that, but that's my recollection that GSR has been provided.
Your Honor, to my knowledge, the information we have, there's been no GSR reports from what was found, if anything, on Paul and Maggie's clothing, because I don't believe they did GSR testing on Paul and Maggie's clothing. There's been no reports found of what DNA was found on Paul and Maggie's clothing and how that cross-checked. I don't believe that was done, and I think that's exactly what he just said to you in a roundabout way, but I don't want to put words in his mouth. We would like to know, did they do DNA testing on Paul and Maggie's clothing?
Your Honor, again, we've provided all the tests that have been done, and that's been provided now for months, is my recollection. They asked for the underlying data, and we provided that as well. And again, if we have a trial issue as to whether or not it would make good forensic sense to test this or that, that could be something that can be litigated at the appropriate time. But there's not anything that has not been provided that we have that has not been provided. In the event that there is, I will notify them immediately, and it will be done in an expedited fashion.
So, sounds like the answer is no. And Your Honor, we don't want to come back years from now with an innocent project where they're testing DNA of Paul and Maggie's clothing and cross-checking it against Curtis Eddie Smith or anybody else. I mean, they have not done it. They have not done it. And we would request the court order them to do it to see if there's Brady material there.
Order them to conduct the test?
Under Brady, yes, sir. They have in their possession possibly exculpatory evidence, but we won't know it because they won't test it.
Your Honor, I'm happy to meet with Mr. Griffin. We can go over and talk to the lead forensic scientist, and we can discuss those issues. And if he has a problem with that, then he can raise that issue. But I think that we need to have that discussion so that he can understand what and what not might be forensically viable in the judgment of the forensic scientist. If he disagrees, he can file something with Your Honor, or they can bring their own expert into a trial and say they should have done this, this, and this, and our expert will say, this is what we did, and this is why we did it.
And we'll take him up on his offer, Your Honor, and we do have our own DNA expert, and we may ask the court to allow our DNA expert to examine. I don't know if they have an objection to that, but we'll explore that. Do you have an objection to have our own DNA expert examine the clothing?
I think that the way this process should work is let's have that meeting first, and in the event we don't agree, we can come to Your Honor.
And then the next item on the list, Your Honor, is GSR. And Your Honor knows those are essentially, GSR stands for gunshot residue. They're particles of that go on people's bodies or in an area after a gun has been shot, GSR. And so we have gotten a GSR report that says that Alec Murdaugh has GSR tested positive on his shirt, tested positive on his shorts. Then it says the GSR kit on his body tested negative. I believe that's how the written report says. Then they produced, upon further request, their logs and their narratives from the lab and communications amongst the agents. And in that communication, Your Honor, the person who did the GSR analysis says that they found 3 particles on Alec's shirt, 3 particles on his shorts, and 1 particle on his hand. Now, my understanding is you have to have 3 particles to test out positive. And there's no particles on his shoes. And also, I don't want to misstate it, but the narrative, the communication appeared that the GSR analyst says that it's most consistent with Mr. Murdaugh holding a gun, which he did have a gun, turned over to law enforcement, that was transferred to GSR, those minimal number of particles on him. But what we have not seen, what we have not gotten, is the data from the microscope or whatever, so that our independent experts can draw the same conclusion. Right now, we're just having to rely upon a narrative note from one person to another saying, this analyst says there's three particles on the shirt, 3 particles on the shorts. And that's the underlying data we have not gotten to my knowledge.
Reporters. Your Honor, they asked for the DNA underlying data, and they asked for the firearms analysis underlying data that matches cases found at the scene with whether cases on the property. And we provided those in a timely fashion. They just asked in the past couple of days for the underlying data for the GSR, to which I immediately said, you got it. I'll get right on it, and it's coming. It hasn't already been provided.
Yes, Your Honor, and we would, again, one purpose is setting a hard date when we're going to receive this, because I believe we did get further firearm analysis. And I did want to point out and clarify so nothing gets misreported here, is that the firearm that Mr. Murdaugh got that I was referring to was after he called 911 while he was talking to the 911 operator, saying he went back to his house to get a gun for his personal protection. That's the transfer GSR from when I made that statement previously. Another big item, Your Honor, is cell phone records and cell phone data. And we have gotten external hard drive about a month or so ago of I think it's 480 gigabytes. But the problem with what we got is you open this external hard drive and there are file names, and then you click on the file name, there's a sub file. You click on a sub file, and then there's a sub file. And then when you go to the data under the sub file, it's empty. Now, it's possible because the way it was copied over and provided to us, and I've had a conversation with Mr. Waters last week about this issue. We have a cell phone guy. We have more than one cell phone expert. It's a big part of their case, they've told us. And we can't get started yet because we don't have the data of the 480 gigabytes that we can access. He had asked me to give the name of our expert so that they can put our expert in touch with their guy SLED, Mr. Dove, and have them figure out what the technology issue is. And I provided that information. In the flurry of these motions, we haven't gotten a response. I spoke to my guy yesterday. I don't believe he's heard from anybody, but maybe he has today. But that's something that we've got to have. So that's number one. We've gotten a hard drive. We can't look at it. Number two, he just referred to the things that we don't have. Apparently, the FBI's doing something with the information that we've been provided. Apparently, FBI's going to do a report of some sort, which we don't have. And they've got their own SLED cell phone analyst who's doing a report, which we don't have. And, Your Honor, we've got to have those reports in order to respond to them with our experts. it would do us no good, and it would be grossly unfair for them to drop these reports in January the 15th. I mean, so they've got 2 reports in progress that they won't produce because they're not finished yet, which is kind of shocking. As we've said, this case was indicted in July, and they're still working on reports for what they just represented to the court it informs the time of death, because it's about when those phones stop moving around. That's all we've gotten is Mr. Waters' representation about that. We've not seen any scientific data to support what he said a couple times in court, now on the record. And we've got to have it. We've got to have it now.
All right, Mr. Waters.
Your Honor, with regard to the cell phones, yeah, we did have that conversation on Thursday. I said we have to do that, and then, of course, I got this motion right here with pictures and all this ridiculousness about polygraphs in it, and then a bunch of other motions as well. And so, hey, let's come to court, and we can talk about that. We're certainly happy to continue to do that, and happy to do that. We're not aware that anything on their hard drive is anything different than we have, and it's no different than what our data is. There's no report that we have for that data, at least, that we're sitting on that haven't been provided. We have the same native data that they have. The FBI, we've repeatedly reached out to them to get their final report, and I believe that's going to be forthcoming in the very near future, and I will immediately provide that to them. The FBI is the FBI, and we're just trying to get that information. But what he's doing is essentially doing a cell tower analysis, which, again, they have the underlying data to do the same thing. If they have 2 or 3 or 4 cell phone experts, as they say. If their expert is having trouble getting into the data, again, I am happy to put those, as I said to Mr. Griffin last week, put those folks together. I'm happy to have that meeting, just like the DNA meeting. I'm happy to have a meeting with their GSR expert. I'm happy to sit down with any and all of their experts and try to work this out so that they're satisfied with what they get. And if there's a disagreement, then they can come to Your Honor. And again, the final, quote, report that he's talking about is, again, it's a SLED agent who's working on a timeline. Again, just kind of synthesizing the underlying data from various sources, whether it's a phone dump, whether it's a witness interview, whether it's a whatever, and putting that together. And again, that's not in the nature of the kind of report he's talking about. And all it is based on the same underlying data that they have, that with their own experts, they're perfectly capable of doing. That being said, when it's ready and it's final and not in draft form, so that issue can't be used, I'm happy to share that with them. I certainly don't expect that to be in return that they're going to do that. Maybe they will, but I'm happy to share that information when it's done. But they still have access to the underlying data to do that very analysis.
Just briefly, Your Honor, we don't have access to the underlying data. There's a technology problem. I think it should be able to be worked through, and we're trying to facilitate that, and I'll continue working with the state on that. But we don't have the data, and we would like, and these reports that are forthcoming, Your Honor, I mean, we need a deadline for that. We need a deadline for that. And we talked about a timeline. Now what we've been informed that they have told, agents have told witnesses who've been interviewed in the field is that so-and-so's phone stopped moving at such and such time. I mean, to our knowledge, we don't know how they can make that determination. And that's what we've got to see. Are they relying on something that would not pass Dahlberg standards? I mean, we've got to have that in order to come to Your Honor and say, Judge, that's junk science. I've been vetting this issue since I heard this was a big issue. And I haven't talked to any expert who says, oh yeah, that phone records a time every time it moves, or that phone records a time when it does this, that, or the other. I mean, I haven't found that person. Now, if they've got someone that's led who's the guru of it, I mean, we need to know, and we need to know whether that's reliable, whether it's tested, whether it's scientific, and so we can challenge it. But for them to just say, oh, it's in progress, is not helpful.
Your Honor, I think he's conflating 2 issues. It is true that phones will record some, and again, I'm not the expert here, but they can record some sort of aspect changes and things like that. What I've said to Mr. Griffin is not that we are basing the entirety of the case on something like that, because he's right. That data can be helpful, but it is not dispositive. What we are basing it on is that despite what Mr. Alec Murdaugh told anybody who would listen, that he never went to those kennels, the phones show that he was there with the two victims shortly before we see meaningful activity on their phone consistent with how they use it. And Mr. Griffin is right when he says, oh, that video, oh, there's no arguing or anything like that going on. He's right. He's right, which might make it pretty cold with him. So again, Mr. Griffin, I think, is conflating the difference between those aspect changes of those telemetry and what I believe the evidence will show. And again, this will be for a jury to determine that around that period of time, both Paul's phone and Maggie's phone stopped showing the usage, the texting, the calling, the movement that their phones typically show. And that's right around the time that they were shot and murdered.
That's what I keep hearing from him, but we haven't seen anything, Your Honor. And what we do know from the records is that Paul's phone was dead. The battery was dead when SLED agents got to him. That's why we need this. We got to get this.
Right.
Both
phones went dead?
Ms. Murdaugh's phone was not dead. Ms. Murdaugh's phone was found a quarter mile down the road.
I thought you said the phones went dead.
Paul's phone was dead. Paul's phone was dead. The next item, number 4 on the list, Your Honor, is complete autopsy file, and this really goes back to the forthwith order. And we have pathologists, and they've asked for where's their pathologist notes, where's diagrams. That's what you normally see in a when you do an autopsy. I've raised that with Mr. Waters, and he says, well, I'll ask. Well, and I'm sure he does ask, but that doesn't mean MUSC is going to give it or going to give everything. I mean, I can promise you, if they get a subpoena, MUSC and the pathologist will give everything. But just because they ask doesn't and I don't know if there are HIPAA issues or other issues that would prevent that. I have no idea. But a court order with a subpoena is more reliable than a request from the state, hey, will you give me your notes? And that's what we're asking for there. And he's not objecting to asking, but we think we need a subpoena for that to ensure we get everything.
Your Honor, we provided on August 31st, 2022, the first day that discovery was authorized by the protective order, the autopsy report and all the autopsy photos. Last week, Mr. Griffin asked for the underlying data. We immediately reached out to MUSC. I had law enforcement do that, and my understanding is that they are fully compliant with that, and as soon as that data is in my hands, it will be in their hands.
Thank you, Your Honor. We'd still like the opportunity to subpoena that to be sure that we get everything. The number 5 is relates to information from their outside expert that they've hired, the group out of Oklahoma. They've done deconstruction of the crime. They have issued a report. We've been provided a report. We've provided a draft report. I think there was another draft that we've not been provided. We've asked for that. And then in the report, there's reference to the mannequins that they, in order to do an angle of entry and exit wounds of the victims, that they did mannequin markups, and we've not seen those. We have our own crime scene forensic expert to respond, but we can't respond until we get all the information created by their experts, and we've asked for that. And we'd like a time period when we'll get it.
Your Honor, I believe that, and it was certainly early on, I believe August 31st, 2022, we provided the report of our forensic expert showing the blood spatter. On top of that, they asked for a PowerPoint that he had prepared, and we provided that as well. They since have been asked for, we've also provided, like you said, some drafts. I will go back and double check. They've asked for some emails related to those. We will take a look at those and provide them. If I have any objection, I will notify defense counsel, and if needed be, we can litigate the issue. So there's no issue with that at all. We provided them extensive information about that anything else that I can obtain, I'm happy to provide, or to tell the defense why not and give them a chance to raise that with Your Honor.
Again, Your Honor, we just need a hard date for compliance. And with regard to the next item on the list, number 6, this relates to bloodstain analysis. Their expert in Oklahoma had done a bloodstain analysis, and what we're requesting is, did you attempt to get another expert prior to landing with the folks in Oklahoma to give you an assessment, and then, you know, and so who was that? I mean, that's what we're asking for there. We'd like to know if they're expert shopping, and if they got.
We did not, Your Honor.
Excuse me?
I said we did not expert shop, Your Honor.
So we understand that they didn't consult with any other potential blood stain analysis experts, is that right?
There are no external blood spatter expert was consulted with. The one that you have the report on was the only one that we went to externally. Is that correct, Special Agent?
Your Honor, I guess the Brady question is, was there some internal expert at SLED who said, you know, I can't make any determination on this, and so they had to go outside? I mean, that would be Brady information, Your Honor, and we've asked for that.
I'll look at that, Your Honor, and if it's available, I'll provide it.
Thank you. Number 7, I understand we got that maybe yesterday. This is the phone, photos of Maggie's phone taken down the highway. And number 8. Number 8 asks for, you know, as a catch-all, lab bench notes for all analysis that's been done. We've gotten a lot of that. I don't know that we've gotten all of that. I know we haven't gotten the GSR, which we mentioned earlier. And if there's any other, like shoe print, lab bench notes, we've got a lot of DNA. So and we sent all that off to our expert. But the things that come to mind are GSR, latent fingerprints or latent prints, and shoe prints. And I don't know that we've gotten that lately, but.
Your Honor, again, you know, just a couple of weeks ago, Mr. Griffin sent an email first requesting the DNA in the firearms. That was immediately provided in a timely manner. They then just recently, in the past couple of days, or I guess it was in the call last Thursday, asked for the GSR, which is in progress. And now in this motion, they asked for, will give us all the lab data. And I'm happy with that. We'll get to work on it. And any underlying lab data that they wish to see, we will certainly provide.
Thank you. Again, you know, we need a hard and fast date, Your Honor, for that. With
they just asked for it, Your Honor.
Yes, we did. With Dave, we'd also, and this comes under Rule 5, any statements of Mr. Murdaugh that they intend to introduce. You know, all the world knows that Preston County recording Mr. Murdaugh's telephone calls, and Preston County produced them under FOIA, but apparently, I don't know if they produced everything under FOIA. I don't know. But if the state is intending to rely upon any written or recorded statements, including recorded from the jail, that they identify those for us. And I've asked for that. And the response is, well, you know, we always wait up until right before trial because we don't want inmates at the jail to know that we're listening to their calls. Well, that's the worst kept secret in this case. Because we had a whole federal lawsuit about that. And we got a lot and whatnot. So, but if they've got recorded conversations they intend to use, they were required to disclose it 30 days after receiving the Rule 5 motion and not wait until he can trial and dump it on us. That's what we're at.
I'm not aware at this time of any jail calls we plan to use in our case in chief. However, we will provide them with the jail calls that we reviewed. We were exceptionally restrictive in those. There are many instances, I believe, in which, we were extraordinarily careful in not reviewing particular calls to avoid any possible privilege issue, even though I believe that there wouldn't be. Since all that hoopla happened with the Richland County's release of those calls, There haven't really been any except long calls going through to Mr. Griffin's office. It may come a time that there might need to be a privilege review of some of those calls, but I'm happy to provide the ones that we downloaded. That is a subset of all the ones that are on there because, again, there were many calls that we were in an abundance of caution not reviewing. So I don't even want to touch those, but I'm happy to provide the ones that we did. At this time, again, though, I don't see us using any of those in our case in chief.
Thank you. Your Honor, number 10 asks for the charts and testing for polygraphs. He said he state says they'll provide that to us. Thank you. We'd like a date for that. Number 11, audio and video recordings of Curtis A. Smith. I believe we got what we knew of that we had not received on the 18th when we received the Hampton County discovery. But if there are others, but I'm not aware of any others. But obviously, if they are, we like them. Going on to number 12.
Excuse me.
I'm sorry.
Your Honor, may I address that point?
Yes, sir.
Everything, as there was extensive Eddie that was already provided. He's mentioned the inadvertence as it related to those two interviews, which of course they had information about, which is how they knew that they occurred. As soon as that inadvertence was detected, those were provided. I'm not aware of anything related to Eddie that they do not have at this time.
Thank you, Your Honor. The item 12 is we located a Google search warrant issued to Google, search warrant number 105, and it requests geofencing data. I think Your Honor signed the search warrant, and it required the return be submitted to the presiding judge within 10 days. And we've not received any return that has been filed or any geofencing data produced by Google. And here it is, October 20th, and I mean, Your Honor, they don't work for Google, I don't work for Google, but I mean, so we put that on a motion. If they have it, we like it, at least, there should be a return that's filed. If they're not filing returns, compliance with Your Honor's order, I think Your Honor would like to know about that.
Your Honor, a couple things about that, and I want to correct some of the things that Mr. Harpootlian was saying before, as he was talking about it. They're pointing to one search warrant. And just a few minutes ago, Mr. Harpootlian was like, those search warrants, they're all sealed. We can't see them. Well, that's not true. They've all been unsealed. They can see them all. He's like, we don't have the returns. We can't get that data. They have all the returns except for this one particular one that we don't have yet. As Mr. Griffin just recognized, I don't work for Google, and I certainly don't own Google, and neither does he. That geofencing is a long process. It is a three-step process. I was just talking to Special Agent Owen about that, and that information is we don't have it yet, but as soon as we get it, we will provide it.
I guess when they get it, when we have an opportunity to challenge if they intend to use it, whether they can use it. And they waited until September 22nd to issue a search warrant for data on it, and the case has been investigated for over a year, and they indicted him in July. I mean, it's pretty astonishing that I read about geofencing in multiple news outlets, some time ago, and yet here in September 22nd, they're issuing a search warrant for this. But we look forward to getting when they get it. The next item is 13, interoffice emails, and I agree with Mr. Waters that there is as a technical rule matter, we're not entitled to every interoffice email that's led relating to this case, but we are entitled to a review under Brady as to in producing anything that's exculpatory and so most people would rather not take a chance and just give us the ESI dump and let us go through there. But they're saying, well, we will review and then we will produce. And again, Your Honor, it's understand that's what they're saying they're going to do. Again, we need a deadline for that in order to get that in a timely fashion. We have a trial date coming up in 90 days. I don't know if you want to address that or not.
I mean, that process has been ongoing, and we've provided a lot of draft reports. I don't know if it's necessarily Brady. I mean, I'm try to be over-inclusive when it comes to that, because it's not worth it. I'd rather them have it than dance on the head of a pin as to whether it's exculpatory or not. And as Mr. Arbuthnot said, I recognize the fact that what I might think of might not be what he thinks of. So we will be expansive and extensive in that regard. It's already been ongoing. Extensive information's been provided. If anything else comes up from that review, it will be provided.
Your Honor, number 14, I put this in based on that telephone conference I had with Mr. Waters, which was very cooperative and helpful, and that he had indicated they had not gotten everything from the Collin County Sheriff's Department or the 14th Circuit Solicitor's files to review, and so we put that on here so we can get a hard and fast date. When you're going to get that, and when you're going to give it to us, because we're at trial in 90 days. That's the request there. And maybe they've gotten a sentence, I don't know.
Yeah, I mean, I know that a lot of Colleton County, the paperwork, the reports and incident reports that we had that I'm aware of, I believe that's all been provided. They have raised this issue with ESI, which is, not really within the rule, but we've been very, accommodating and trying to provide that stuff. I need to go back and check on the ESI to see if there's anything. But my understanding is any substantive report or anything like that has already been provided.
Great. Did we get the body cam videos from McMillan and Kander in the most recent?
So yes, the last one of their motion to compel, they asked for a body cam for Debbie McMillan. That was turned over on August 31st, 2022. The file name in the discovery that was provided to the defense is 0061-Deborah McMillan 61421 interview. Base level is SGJ 43. Audio of the Grand Condor interview was turned over on June 9th, 2022, and then the body camera video was turned over as of yesterday.
When? Yesterday. Thank you. Your Honor, one last item that I overlooked with regard to when I went through the information that we were requesting about Mr. Smith is the terms of any agreement, non-prosecution agreement or otherwise, that they have with him. They did produce a proffer agreement. And Your Honor knows the proffer agreement is not a cooperation agreement, it's not a plea agreement. And by its very terms, it says that if you fail the polygraph, you are in violation of the proffer agreement. And the state can use all the information that you provided during those proffer interviews. Well, we've been informed that the state intends to present Mr. Smith as a witness. And so if they have any unwritten agreements, any agreements whatsoever, I mean, we're putting them on notice that we want the contents of those agreements under Giglio, and that, and Mr. Waters, I'm sure he doesn't have a signed agreement, but if there's any understanding with Mr. Smith or his lawyer, with anybody in law enforcement about what's going to happen to Mr. Smith's case after he testifies in the murder case, we're entitled to know it, and so we do request that.
Your Honor, I'm well aware of my obligations in that regard. There is a proffer with Mr. Smith, which has been provided to them for months. And again, I mean, I know Your Honor knows what a proffer is, but a proffer is not a cooperation agreement. It is not a plea agreement. Our proffer even says that in bold language. This is not a cooperation agreement. It's only an interview agreement. And it does have a polygraph requirement. There's also a breach letter, okay? And so there's no wink, wink, nod, nod. There's no non-prosecution agreement with Mr. Smith. As much as they want to make this case about Curtis Avery Smith and talk about a polygraph and talk about some scuttlebutt story that is really offensive, this case is not about Curtis Avery Smith, okay? To use a term of art, Curtis Avery Smith is not the center of this particular case. This case is not about Curtis Avery Smith. There's no agreement with him. There's no non-prosecution agreement with him. We declared him in breach of the proffer, and he's currently indicted for 19 felonies in this particular investigation, and he's currently in jail based on the state's motion to revoke that was heard by Your Honor. So there's nothing that is out there that needs to be disclosed, and if anyone committed any crime related to this investigation, they'll be charged.
Your Honor, just in concluding our motions, I just can't help but point out that Mr. Waters knows that Mr. Smith visited the murder scene on numerous occasions before the murders to commit illegal acts by leaving drugs there. So we know he knew how to get there surreptitiously. We know he failed a polygraph. We know his DNA as of today has not been tested under Maggie's fingernails or on the defendant's, on the deceased clothing. I'm not saying he did it. I'm just saying certainly sounds like he could have done it. And we have a duty under our obligation to client to pursue that until we come to some conclusion. I understand it's inconsistent with the conclusion the state's come to. That doesn't make it not true. So that's number one. Number two, we've outlined a number of things here where we hear, we're gonna get it to you. We're working on it. We got a trial in 90 days. Give them a week, give them 2 weeks, but they need to give us the material we've asked for. He concedes we're entitled to it. And, Your Honor, I would ask you to give us the forthwith order so while we're waiting on them to do what they're supposed to do, we can go do it ourselves. We've got experts waiting for materials. MUSC, they've asked, and I, like you, I was a prosecutor long ago. And sometimes, I know this sounds shocking, but you may have memories of it, where prosecution witnesses don't give everything they're supposed to. Now, when they get a subpoena, they produce it. When they get an ask, even from someone of Mr. Waters' stature, sometimes they don't comply. So we'd like the ability to serve subpoenas, to get materials, like the autopsy sketches and notes, which our expert says are invaluable in assessing the accuracy of the autopsy results. The same thing on these GSR results. There are 3 particles according to the SLED report. We've got our own GSR expert, 3 particles. We don't have the bench notes. We don't have, those 3 particles are consistent, according to their expert, with him going and getting the gun from the house after he finds the body. And their expert and our expert on crime scene would indicate whoever shot Paul would be covered in GSR, covered in blood, and there's no evidence whatsoever of that for Mr. Murdaugh. And the last thing I'd say is this. I am not accusing, and I don't want the record to imply that I'm accusing Mr. Waters of anything improper or unethical. What I am saying is this: his efforts, no matter how well-founded, aren't going to be enough if we get it in late November or even mid-November before Thanksgiving, and our experts can't have the opportunity to examine it. Somebody needs to look at that shirt on Paul. Somebody needs to look at Maggie's clothing to see if there's DNA. They haven't done it. And we're going to have a discussion. And if they haven't done it, we want to do it. So, and we can't wait 60 days to do it. We need to do it in the next 2 or 3 weeks so that our experts can come to a conclusion so that we can begin fashioning a defense in this case. And the last thing I'd say is this. The more we get from the state, the less we believe they can prove our client guilty beyond a reasonable doubt. Let me repeat that. The more we get, the less convinced we are. So the quicker we get this, the quicker we can be in a position to challenge each and every piece. There's no eyewitness. There's no confession. There's nothing but circumstantial evidence. Your Honor, you and I as former prosecutors understand, those are tough. Those are tough for a prosecutor. And so we want to make sure that we can, the old charge used to be each circumstance is like a link in a chain, if one of them breaks, that we don't charge that anymore. But it's still an approach. And so we need to see each link, like, tell us when you think they were killed. Are they relying on the coroner's estimate of 9 o'clock? They've not said that, because that's what's on the death certificate. 9 o'clock is at the time of death. Or is it, 10 o'clock? They just can't, I mean, they've got to be more specific, and they need to comply with Rule 5. Again, I want to make it clear, I'm not accusing the state of unethical, illegal conduct. I am frustrated with their lack of diligence in getting this material to us. Somebody's working on it. Somebody's asked for it. We'll get it to you. Please set a hard date for them to comply with Brady and with Rule 5. Thank you.
Your Honor, this discovery is massive, and we have been working as diligently as ever. Many of the things that they're talking about here today, they just asked for, okay? And we are immediately responding. Mr. Griffin conceded over and over again, yep, I have my list. I called up Creighton. I said, what about this, 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 and this? And I said, yes, 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 and yes. Didn't say no to a thing. So I don't know that we need to. I like to be able to speak without being interrupted, if I could, Your Honor, please. And so I don't think that now's the time for that sort of thing. We all know that how important this is. We all know the stakes, and the state's being very, very diligent. Mr. Harpootlian just talked about a circumstantial case. And Your Honor, as a former prosecutor knows, there's nothing wrong with a circumstantial case. If every murder case needed a confession and an eyewitness, it'd be open season out there. There's nothing wrong with a circumstantial case. The forthwith order is unnecessary at this time. I've already told them that I would meet with them. I've already told them, and they act like that a law enforcement going to MEOC to get the notes is going to be, well, they're not going to provide it all. They will provide all of that. So it's not authorized at this time. It's also not authorized by the rule. I mean, expressly, when they changed Rule 7 and put that in there, it's very clear in the criminal procedure rules that only subpoenas are allowed to come to some sort of court proceeding. All right, and that's in distinction to Rule 45 in the civil rules, where it does allow for things to be subpoenaed ahead of time. So the rule's very clear, and the comment even talks about that it's only a court proceeding. So, Your Honor, I mean, we've made some legal arguments in our brief about that, but it's very clear that this particular rule, which was adopted in the manner it has to be adopted and approved by the General Assembly, it specifically excluded what they're requesting. And so it's okay, I think, to just do it the way it should be done, and that is if they have a problem, they can come to Your Honor. But I will do anything in my power within reason to facilitate any additional information they want. If I can't do it or I won't do it, I will tell them why, and they can raise those issues at the time. That's the way it's supposed to be done, and that's exactly what's contemplated by the rule, even after it was changed in 2019, where they specifically kept that court proceeding requirement in there.
Which rule are you now referencing?
I'm sorry, I misquoted. I'm talking about Rule 13, Your Honor, under the rules of criminal procedure. I said 7, I meant to say 13. And if you look at the rule, Your Honor, it says within it, bear with me for a second. All right, so if you look at the sentence, it says the subpoena shall state the name of the court, the title of the action, and should command each person to whom it is directed to attend and give testimony or otherwise produce documentary evidence at a specified court proceeding. That was specifically let in there. If you go down to the note, it says, note to the 2019 amendment, and I believe it's the second sentence, says the amendment also makes clear that subpoenas may only be issued to summon a witness to appear or present documentary evidence at a court proceeding. That was a very specific judgment made by the, frankly, constitutional procedure in Article 5, Section 4A of our Constitution as to how rules of procedure can be adopted and approved. And so that's, and again, it's in contrast to Rule 45 in the civil rules that specifically allows a subpoena to subpoena things ahead of any proceeding. So the only solution allowed by the law is what we're proposing, and that is that if they have a specific issue, they can seek an order from Your Honor.
Please, Court, Your Honor.
Yes, sir.
We don't believe the rule excludes it. If Your Honor believes the rule does exclude it, I'd ask you to set a hearing for November 10th before this court, so that we can subpoena everything to that November 10th hearing, which would comply with the rule 100%. And unlike the civil rules, we don't have to serve the state with a copy of the subpoena in a criminal case. Matter of fact, it's not required. So what we would propose to do is subpoena to that hearing. We'll use this notice. It says they can come, they can tell us, and we'll make a motion to compel. But we can go ahead and get out 5 or 6 subpoenas, if Your Honor will order that, almost immediately. You just said, if that works for you, November 10th, that gives us basically 3 weeks for people to get them and respond. I don't know, would the state object to having a hearing on November 10th for us to subpoena stuff?
Your Honor, we just spent probably an hour or however long it was going through request by request by request by request, many of which they either already had or they just recently made, and I don't recall a single one of them where the answer wasn't yes. So I don't know
Go ahead, I'm
that
sorry.
there
I
needs to
apologize.
be that at this point, Your Honor. And we all understand the trial date coming down the pipe, but there's no need for this at this point. If they have a specific thing they need, that's fine. But right now, every single thing they've raised, our answer has been, if we got it, we'll get it and we'll give it, or we already have given it.
Your Honor, here's a simple solution to that. There's stuff we want, they don't have. They don't know about, that we ought to be able to compel to get by serving a subpoena. If the people give it to us, they'll never know about it until trial, unless we're going to use it in our case in chief. Why can't we do that? There's no Brady obligation on us. There's no Rule 5 other than the specific responses. If you'll set a hearing date, we'll subpoena, and the people that don't want to fight about it, we'll get it. They'll never know about it. Well, and why is that not what this system is about? Why do we have to tell them why we need something? I mean, this is not. They're the ones that indicted this case 3 months ago. They're the ones that said, we're ready for trial. They're the ones that decided they had enough evidence to convict Mr. Murdaugh beyond a reasonable doubt. We didn't do that. They could have waited a year. They already waited one. I don't know what the hurry was. But now they want to say, whoa. We'll get it to you when we can get it to you. Number one. Number two, we want to know everything you want that we don't have. They're not entitled to that. So if you want to set a hearing, we'll subpoena it. The people that give it to us without objecting, we'll be fine. If they do object, we'll come. It'll be a public hearing, and Mr. Waters can weigh in, although I don't think he's got a right to do that.
Your Honor, I'm not on the Supreme Court, obviously, and I'm obviously not in the legislature either. I didn't make Rule 13, but the appropriate procedure did. So all I'm doing here is saying this is what the rule says, and this is what the acceptable procedure within that rule is. I had nothing to do with that rule. That's just what it is.
But Rule 13 doesn't prohibit subpoena to a hearing. And that's what I'm proposing is a middle ground. So that we don't have to debate what Rule 13 means. It says you can subpoena it to a court proceeding. If you set one up, we'll subpoena it. And if they object, we'll come to that hearing. We'd like it that week, not the Tuesday of that week is election day, but any time after that date. Your Honor.
Anything further?
No, Your Honor.
Nothing from the state, Your Honor.
Oh, yeah, one other matter. We attempted to waive Mr. Murdaugh's appearance here today, as I put in my email to you and to Mr. Waters. He wanted to not be here today because they truss him up like some sort of animal. I understand his procedure, and they transport him from the jail and they bring him here. And he, as you've seen, hasn't really participated in this process. He is an attorney. We've reviewed the motions with him. He really has no interest in being here today and listening to this. So I've talked to Mr. Waters. I would propose that in the future, that if he does not want to attend a hearing, that he sign, notary is difficult to do at the jail, but sign a statement, and we represent to the court that he waives his appearance, and we will send that to the court, scan it and send it to the court and Mr. Waters in the future. So if he doesn't want to be here, which would save law enforcement a tremendous amount of trouble. And again, he doesn't need to be here for these procedural motions.
Your Honor, Mr. Murdaugh is not trussed up like an animal. He's transported by some of the most professional SLED agents I've had the opportunity to work with.
Stand up.
Mr. Griffin and Mr. Harpootlian emailed, as you're well aware, yesterday and said they wanted to waive his appearance. Of course, I objected to that. I said this matter is too important. We need a colloquy on the record. If Mr. Murdaugh doesn't want to attend the hearings for his own case where he's accused of the murder of his wife and son, if he doesn't want to,
I object to this.
that's what we're here to talk about.
This is
I'd
not.
like to comment on your argument, Mr. Harpootlian. You may proceed, Mr. Waters.
Thank you. If he does not want to attend his own hearings in the murder case against him for the murders of his wife and son, okay, that's fine. I remember an argument before Your Honor not too long ago where we were talking about the protective order, and they were saying, he's a lawyer. He needs to be able to review all this material. He's got to look at all of this stuff. And I said, well, he was a lawyer. And that was the discussion then. If he's not interested, that's fine. But we need to have a colloquy on the record. I would suggest we do that now so that he understands his right to be present. And then if that's fine, we have that record and the record's protected. so that down the road, there's no issues there. Then after that, if we get something written in the nature of an affidavit, if he doesn't wish to attend a particular hearing, then I think we've got the record protected and the record covered. That would be the procedure I would suggest, Your Honor.
If it please the court, Your Honor, almost every day this week, because we cannot leave discovery materials at the jail. We've seen down in Charleston what can happen. And we're under an order not to do that. This attorney with my office, Mr. Neese, goes to the jail and sits for 4 or 5 hours with a laptop while Mr. Murdaugh reviews the terabyte or half a terabyte or whatever data we have, so that he then can give us his information on the state's information. He's missing that today. We're 90 days away, and it's going to take every one of those days for him to review that material. So it's not he doesn't want to be here. I think he's got a more productive time spent with Mr. Neese reviewing the discovery material and giving us, he can point out, and he has, significant errors and inconsistencies in the state's case. That's more important than him sitting here and listening to Mr. Waters and I back guns against each other. That's number one. Number two, I'll be happy for him to represent to the court, and he would raise his right hand, but he's trussed up like an animal. Go ahead and stand up. If you want to swear that he's willing to waive, given for written document.
Madam Clerk, if you'll swear Mr. Murdaugh.
Raise your right hand, do you swear or affirm that the testimony you give is the truth, whole truth, and nothing but the truth? So help you God.
Yes, ma'am.
Your Honor, you'd like to inquire? Well, I'll inquire. Mr. Murdaugh, you've indicated that you you're willing to waive your appearance at hearings based on discussions with Mr. Griffin and I, correct?
That's correct.
Some of them you want to be here for?
Absolutely.
Some of them you would find more productive being with Mr. Neese reviewing materials, correct?
Yes, sir.
Now, have you found these materials voluminous?
Yes, sir.
And it's slow going on the computer, is it not?
It is.
So you and I talked about it's probably going to take you right up to the trial date to review what we've already gotten, and we got more yesterday, correct?
Yes, sir.
So you and Mr. Griffin and I will discuss whether or not it's necessary for you to be here, correct?
Yes, sir.
And if you decide and we decide and you agree that it's not necessary for you to be here, you will sign the appropriate document waiving your appearance, and we will furnish it to the court. Is that agreeable to you?
It is.
Your Honor, if I could suggest one additional question, and that is that Mr. Murdaugh understand that you have the ability to be here and that law enforcement will transport you each and every time. Do you understand that?
I do understand that.
Right, and so if you're waiving that, you realize it's not a problem to make sure that you have the right to come in here and sit in here and hear what's going on in your case. Do you understand that?
I do.
Thank
you. Anything else, Your Honor?
Regarding Mr. Murdaugh appearing or not appearing, the court will address that on a day-by-day basis as we have hearings scheduled, as the defendant has a right to appear, and certainly in the trial he must appear.
Oh, absolutely.
We'll examine that as circumstances permit. I agree with Mr. Waters. Prior to today, there have been no colloquy with Mr. Murdaugh regarding his right to come on that.
Well, I believe the record is fully protected now. And Your Honor, again, if you believe it's necessary for him to be here, even though he has waived his right, well, we won't have any objection to him coming.
Yes, sir.
Thank you.
With regard to the hearing today, pretty much addressing Rule 5 of the South Carolina Rules of Criminal Procedure regarding disclosure in criminal cases. These rules were adopted by the General Assembly in 1988. They govern criminal cases for not just Mr. Murdaugh, but all of the accused in the state of South Carolina. These rules have been tested over time, and they have proved effective and efficient in assisting in the preparation of cases and ensuring the defendant's right to a fair trial by imposing certain obligations on the state as well as on the defendant. So to the extent that any precedent is set as a result of this case, it would apply not just to Mr. Murdaugh, but to every other defendant and every other criminal case in this state. So the court must use utmost care and caution with regard to issuing orders that may be precedential. A motion was filed, a forthwith order in which the defense counsel seeks an order granting the defense authority to issue subpoenas requiring the production of documents. It is an order that is, if issued, would be akin to an order of production in a civil case or discovery order in a civil case. It extends beyond the current mandates of Rule 5 and Rule 7. That being said, it is due to the complexity of this case, it is essential that the defendant be given adequate discovery rights to ensure that he is fully prepared to defend the charges against him. The court will not issue a blanket order. It would be unprecedented as far as this court is aware of. The court will address any request for discovery or subpoena on a case-by-case, incident-by-incident basis. The court will not set a hearing on a non-existent motion, but only on motions that have been filed in court, not set a hearing in anticipation of something being filed. With regard to the state's compliance with discovery, first, this hearing is set based on the motion for a forthwith order. In the interim, several motions to compel discovery were filed. Several motions were filed. The parties have been in contact with each other. I do not find any lack of diligence on the part of the state in complying with discovery. This case is set for trial within 6 months of indictment, whereas cases are typically set for trial maybe 18 months, 2 years, 3 years of indictment. So this case is on a compressed schedule that places a tremendous burden on both sides to get prepared for trial. A reference was made to the federal rules. Perhaps if the state had a rule 37.1 requiring, that is in the federal rules, requiring parties to confer and to attempt to resolve differences prior to filing motions and seeking hearings, that would, and is required under the civil rules, the obligation to confer with opposing counsel prior to seeking relief by the court, and only after an inability to resolve matters with each other, then the motion is filed. And that duty to confer in the civil rules is rule, rule 6, 7, 8, 9, 10.
Well, Rule 11 requires you to write to the other side. And
Rule 11, there you go, thank you. So we have Rule 11 in criminal court that might expedite things to some degree. But nevertheless, we are where we are. And I find that with regard to most of the matters in which the defense is seeking production, that the state is making a good faith effort to comply, there is a continuing duty to disclose. Many of the items requested, the state is under no duty or obligation to perform testing or to gather evidence that for the benefit of the defendant, though the state is under an obligation to produce any grading material or bibliographical material that might be helpful to the defendant. Given the compressed nature of the trial schedule, the ongoing nature of the testing, gathering documents, and discovery material, I think that both sides are doing an admirable job in preparing the case for trial. It should occur that given the compressed nature of things, that all discovery is not done within a timely manner as to afford Mr. Murdaugh a fair trial, then that any other matters regarding that will have to be entertained by the court. However, it appears that we are on schedule to be able to have this trial in January, provided that these matters being tested are tested and concluded in sufficient time for the defendant's experts to review. With regard to the notice of alibi, the rule provides that upon request of the state, the defense must provide a notice of alibi and to provide sufficient information so that the state can investigate this alibi if one exists. The rule does specify that the state must state a time and a place and a date. Of course, when the rules refer to time, it does not specify an exact time or exact minute or second, but sufficient notice to put the defendant on notice as to what the accusation is, such that the defendant can respond to the accusation. The time frame referenced in the discovery material sets a fairly close time parameter that addresses the requirements of Rule 5E. The state references Rule 5E1, requesting that the defendant serve written notice of his intention to offer an alibi, shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of witnesses upon whom he intends to rely to establish such alibi, in order for the record to be clear as to the state's request and require the state to specify in writing the time, date, and place at which the alleged offense occurred, to the extent that it complies with the mandates of the rule. Though I do not find any violation of the rule sufficient to require the court to strike the notice of alibi filed by the state. And therefore, denying the motion to compel based on the finding that the state is in compliance and is complying on an ongoing basis with Rule 5, I will address any issue regarding subpoenas, reflected the spirit of this court with order requests. I'll address that on an instant by instant basis, case by case basis. Are there any other matters I need to address?
Your Honor, just to clarify, so if we want to subpoena something, we can come to you ex parte.
That's what you would like to do.
Well, Your Honor, I mean, again, when they came to you with a search warrant on September 22nd, they didn't check with us first. They have the ability to issue search warrants. We don't. There's no requirement that they serve us with a statewide grand jury subpoena or any subpoena that they issue pursuant to the statewide grand jury, which they have the authority to do. They don't notify us. And so I'm just saying, to the extent that we're issuing subpoenas, it would telegraph perhaps our defense. And again, Your Honor's indicated the rule doesn't, I mean, it would be precedential for you to do this, although other judges have done it in other cases. I'm not asking you to do that.
Any cited cases or
Any what?
any
No,
cited
no.
authority within the state
Never
of
been.
South Carolina?
Well, there've been, we both have had cases when judges
Any
have done it.
cited authority?
No, sir, because nobody ever appeals it. It's never been an appellate issue. No prosecutor I've ever dealt with ever objected to it. But here we are. So Your Honor has a chance here to make some law. And I would suggest that,
I'm not interested in making any law about that.
well, you're going to in this case, trust me, whether you want to or not. And so all I would ask is this: let us submit to you an ex parte petition. If you find it something that is offensive, you can inform the state. But why should they have the ability to weigh in on we're not subpoenaing them. We're not subpoenaing their agents. We're not subpoenaing their materials. We're subpoenaing a third party, a civilian out there. Why should they have the ability to weigh in and object?
As I indicated, I will consider any request, motion on a case by case, instant by instant basis. I'm not issuing any blanket authority conferring upon the defense.
I just don't want to offend you by serving a ex parte petition on you.
I've never offended you.
Yes, sir. But, and one last point. Your Honor's not set any deadlines. I hear what you say, they're making a diligent effort. But we're going to get to a point of no return in the not too distant future.
And if there's such time that the court has to convene a hearing, we'll do so. It appears that there's a meeting, a response to the meeting, discovery provided. Whereas I thought there would be a lot of conflict and confusion, parties are in agreement as to many things.
Many
So
things.
if there is a need for a further hearing upon motion, the court will entertain it.
Well, we may be doing that early next week if we don't get immediate response to some questions we have. And look, it is compressed. He agreed to it. No court independently ordered him for a trial on January 23rd. We made a motion to try it in October. He said he couldn't do that. November, couldn't do that. January, we agreed, all of us. No one is here. What we're saying though is we agreed based on the understanding that we get the discovery materials. And I point out one last time, we asked for the materials we got last night on the roadside shooting where Curtis Eddie Smith was interviewed. And now we know his DNA was taken there. In January, this is October. So that's not diligence. So I would just say that is an example. Now, it's inadvertence. I'm not saying anybody held it back, but he shouldn't get convicted because of inadvertence.
Of course, this is not a motion carried on the Smith case. You're referring to the separate indictment.
A separate indictment in which one of their witnesses, they indicate he's going to cooperate, gave statements, which are, the little we listened to last night, are pretty outrageous. I could recount them, but Mr. Waters would jump up and down. But I mean, it would indicate some knowledge of guilt on his part as to the murders. That's all I'm saying. Thank you.
Mr. Warren, final words.
Your Honor, I think you've already ruled, so I have nothing further from the state. Thank you.
Very good. Thank you all.
Thank you, Your Honor.
Thank you, Judge.
Recess. Take a few minutes and let you see.
I'll be driving very fast. What? Dick and I can get in a race on the island. I'll beat you.
So here's what we do. The second you get. It's very hard to get.
Yeah. You can get that other paper.
Yes, I was,
You can grab the
Where's the microphone?
Doing well, Ian.
Turn them off. Open it up. You gotta hold it. Otherwise, that just needs it. This is ours?
Oh, thank you.
No, that is not.
Within the Murdaugh case, there are so many villains who are easy to identify, but not all of these evildoers are obvious. As these cases continue to twist and move forward, we will continue to drag these vampires into the sunlight and show the world who the true villains really are.